the matter of crime secretary of state for Commonwealth And Development Affairs. I think your lordships probably have the appearances. I appear with Mr. Tim James Matthews, Mr. David Blundell, King's Counsel, and Mr. Femi Adekoya, represent the Secretary of State.
Yes, thank you.
The other feature of the case that I'm sure, again, your lordships have noticed is there is some material that's in a confidential bundle. Since this case is, as I understand it, going to be live streamed, it would clearly be extremely inconvenient were I to ask the court at any point to hear something in private, and therefore I will try throughout this hearing to refer only to the public material, if necessary, asking the court to look at the confidential material without identifying
that we do actually have a pause button, but I've never had to use it.
No.
But everyone should be careful.
Yes. Again, as I'm sure you will have had a chance to read into this, you will have identified that there are 3 grounds that are to be raised with the leave of the single judge, and a 4th, which is concerned with the adequacy of the judicial review provided for under the Act.
Yes.
And that will not take a lot of time. I will deal with it at the end. But in a sense, for all the 3 grounds in relation to which leave has been granted, there is a core central issue, which is the treatment of what I'm going to call pure associates. That is, people who only qualify for designation because they are associated with someone who centrally qualifies as an involved person. And as I will shortly show the court, the reality is that the associate category widens by a factor of possibly 20 or 30 times those who may be caught up in the sanctions regime because they have an association, an original association with a centrally involved person.
Yes, in my own thinking, I've called those people principals.
Yes.
Or players.
Yes.
There may be a better term, if so I picked it up.
Yes. And my calculation of there being perhaps a factor of 30 or 50 is necessarily a crude one, as we will see in due course. If one takes immediate family members with a typical nuclear family, 2 children, that would give you a multiple of 17 once you catch aunts and uncles, nieces and nephews, grandchildren and grandparents.
But hang on, perhaps if you're going back to this in detail, do. It doesn't really matter. Your point is that there are likely to be more associates than principals, but I obviously have no idea about how the system works more generally, but in the present case, only one associate is directly sanctioned.
Indeed.
Namely the appellant.
Indeed.
It obviously has effects on children.
Yes.
And indeed, as we know, on staff and
yes.
all sorts of ripple effects on other people. But it's not helpful to count those in your 20 or 30 time.
No, I mean, one can look at these cases and all the issues that arise, for example, proportionality, either at a high level of abstraction as to how the scheme generally works, or looking at the particular case and the particular individual circumstances. And the cases suggest you have to look at it in both ways. You look at the scheme as it operates at a general level, and that does provide at least a reason for the court to think about, well, you've got one player, but you've got 50 people connected to them. How is that going to operate? And then to look at the particular case and say, well, actually here, we've just got one player and one associate.
And sorry, just to be technical about this also, I think associates, although there will be, the only categories of associates are spouses and children. Isn't that right?
No, my lord.
Sorry, I'm wrong.
So it's aunts, uncles, nieces, nephews.
I'd forgotten that. I've only looked at the ones that interest me.
No, I will show you, I promise you.
Okay, that's fine. Forget that. Go on with the main point.
Really, my introductory remarks were intended to convey the idea that this is a statutory scheme where the associates by a significant multiple, will represent by far the largest class of persons who are likely to be subject or are liable to be subject to sanctions, and yet it is completely undefined, we say, in a way that raises questions about Padfield purpose as well as whether in accordance with the law, because it is such a wide pool with no indication as to who is going to get chosen out of that wide pool to be the subject of the sanctions regime. That's really the introductory point. And what I was going to accept is that it means there's a degree of repetition. So I say because it's such a wide pool, you can't say it serves a Padfield purpose, and because it's such a wide pool, you can't say it's in accordance with the law or rationally connected, because without some defining characteristics, either in the legislation or in non-existent guidance, you just don't know who is going to be chosen out of the associate pool for the purpose of designation. So that is an in advance apology for repetition, but that lies at the heart of the case that we advance on the main grounds. So far as the circumstances of this particular appellant are concerned, again, I can probably take it relatively quickly because it's dealt with, at least to some extent, in the judgment below. But I just perhaps ought to highlight by way of summary what we say the judge below found and what we contend are the relevant factual circumstances that may have to be considered. Firstly, that this appellant is personally blameless in relation to any aspect of Russia's conduct in relation to Ukraine. She is also utterly powerless to enforce any change in that situation. The judge records at paragraph 3 of her judgment that it was common ground that she had no political involvement, had given no material support to the regime, and had no economic influence. She also, perhaps it is just worth noting, in addition, in the judgment noted that one of the ironies was at the point when the sanctions were imposed, this appellant, along with her eldest daughter, were housing Ukrainian refugees. The second point I would make is that the associate status arises because of the historic facts of her relationship to her husband. He has provided her with financial support, and he obviously is connected with her because of the family relationship. But as your lordships will no doubt appreciate, they got married in 1992, I think before President Putin had even started on his political career. And the significant parts of the husband's business activity are described in brief in the appellant's statement, but it's clear that the move to the UK came in 2013 after the Rosneft takeover of TNK BP, which was one of the principal businesses in which her husband was involved. And she describes in the confidential statement at paragraph 21 the circumstances of that takeover and the approach of the then government of Russia, President Putin. I think may have been succeeded by President Medvedev, I lose track of it, but in any event, she describes in the confidential statement circumstances that she says attended upon that sale. But suffice it to say that there is nothing she can do about her associate status, and at the point when she married her husband and started to receive support as a stay-at-home mother, there's nothing she can do about the fact that she has benefited from that relationship. So that's the second point. The third point is that at the point when she is sanctioned, she is effectively operating as a single parent. Because by the time she is sanctioned, her husband has been sanctioned. And because he is not a British citizen, that sanction operates to designate him as an excluded person. So he loses any right to remain and cannot be admitted to the United Kingdom whilst the sanctions last. So at the point the sanctions fall on her, she is a sole parent looking after, with 3 children at home, all British citizens, the youngest of whom is 9. I think the judge below says he's 10, but he's 9 at the point of sanctions. And the impact, as I think my Lord the Vice President has pointed out, falls not just on her, but on those children who are at home and dependent on her. So I'm sure the court has seen the reference to those who are subject to sanctions as prisoners of the state. But that does need a bit of fleshing out, because the reality is not only is she entirely unable to provide any material protection or even basic foodstuffs for her children and herself without the consent of the government. She's unable to accept any assistance or charity from anyone who would otherwise want to help her. Because as soon as someone knows that she is a designated person, they would commit one of the range of criminal offences which are committed by anyone who seeks to provide financial support to someone who's designated. Financial or any material support to someone who's designated. So she is utterly exposed to the decisions of the state. And then finally, so far as
you'll give us the reference for those offences, will you? When
I come to the regulations,
yep,
and
okay,
the Act, I'll show you them. They're in here.
Yep.
And then finally, because she is a UK national, she is unable to, at any stage, avoid the consequences of her status, because as a UK national, she is subject to the sanctions prohibition anywhere in the world. So the consequences flowing from those sanctions were obviously, because of the statutory scheme, immediate, grave, and have increased in their gravity as the years have crept by. So it may perhaps just be a matter of observation as recorded by the judge, but the reality is that it took nearly 3 months for even a basic needs licence to be granted. So for the first 3 months, unless you had food in your store cupboard, you couldn't buy anything, whether it's train tickets or tube tickets or food, without authority, and she had none.
The evidence doesn't show how she coped in that period. I doubt if she had 3 months' worth of food in her fridge.
Indeed.
We don't know.
Yeah. No, and what happens is you effectively you have to write to the Secretary of State saying you haven't granted it, therefore I am going to have to go out and use this mechanism. There was some cash in the house, as I understand it, but you have to confess that you've done that, and that's what happened in this case.
And would the failure to grant a licence in those circumstances be itself justiciable?
It would, and that's a suggestion that is made, I think, quite forcibly by the Secretary of State, but your Lordship has to bear in mind the reality of the judicial review mechanism as an effective means to do that. Quite apart from you have to get a licence for funding in order to launch your application, you then have to face the time that even the most urgent JR will take to come on.
Yes, in fact, you're right. You can't do JR without a lawyer. Well, you can, but and if you've got to find a lawyer who's willing to do it for nothing until the license.
Well, you can't even do it for nothing because that's providing her. That's what the relevance of the offence is. That you can't provide material support because you know.
Would that include acting pro bono in legal proceedings?
It would potentially, yes. It would, because you're providing services. In any event, I am sure any lawyer would be
cautious.
Would be very cautious. And apart from the else, I mean,
help us on that later.
One of the historic facts is there is an issue as to whether the lawyers are insured to carry out sanctions work, because it's regarded now as being a separate risk that has to be separately insured. It's not treated as standard in the...
Not covered by your public law coverage. No.
So...
Hang on one second, there's something ahead. Just so that I don't lose this, what you're telling us on instructions, I don't suppose it'll be contentious, but the way in practice this worked is that you break the sanctions regime by using cash you happen to have stored, but you own up to mitigate anyone doing anything about it. Yes, I see. So it's not, you might think that it's part of the sanctions regime that the moment you designate, in circumstances where someone has no other assets, you'd have to give some kind of basic license straight away.
Indeed.
At the same time. That doesn't happen.
Like the freezing order, which makes immediate provision for living expenses, legal expenses, etc.
Exactly.
Because you know there will be living expenses and you know that there will be legal expenses. Yeah. And is there any reason what?
Yes. So I'm being told that there is now a general license for basic needs granted, but there wasn't at the time this happened.
Hang on one second.
Do you know when that was introduced? Don't necessarily answer that now.
I'll find out, my dear.
Would you?
Yes.
Yeah, well, again, I'm sure Mr. Underhill will be able to help us on that.
But obviously, even with the basic needs, if one parks basic needs, the reality is that sanctions will also have an immediate effect on the security of your home, because you do require authority to spend money on utilities, you require authority to maintain security, although in this case the...
Well, okay,
Yes.
That's one thing, but the absolute fundamental basic needs, however they're defined,
Yes, were not provided for in this case.
Takes a lawyer to say these legal needs are absolute priorities.
Yes.
Legal needs because of the situation to which you've been put, and basic needs because you've got to feed yourself.
Yes.
And one would have assumed that those were built in from the start. As my Lord says, the parallel is what happens when you do an assets freeze in civil law.
Indeed.
Okay.
And then, obviously, I've mentioned security of your home, security of your health treatment. The basis for it will change immediately. I'm not going to dwell on it. The appellant is a cancer survivor. There was a significant change in the healthcare that was available to her, albeit she has got National Health Service coverage. And there was a significant change in her ability to travel. She still has a mother who is still a cancer survivor under treatment in Moscow, and her husband is there. But I probably don't need to dwell too much on the consequences for her, which are devastating, because the consequences for the children had been much more severe. Again, it's dealt with in the confidential statement, but the youngest daughter, who was living at home at the stage, had had a long-standing psychiatric condition, and the support for that disappeared and had to be provided by way of the occasional special licence and now very thin stretch National Health Service coverage for that particular form of psychiatric disorder. The youngest son, who was 9 at the time, suffered from very high levels of distress. Obviously, he had lost his father because he can no longer enter the United Kingdom, and in due course, he was forced from his settled schooling by the decision-making that deemed that it was not appropriate for him to have the benefit of private education. And as the judge records in her judgment at paragraph 142, he had suicidal thoughts, he had been diagnosed with depression and anxiety, and that continues to be the position to this day. The only point that I need to correct from the judge's judgment is that at paragraph 67, she describes how the youngest boy had been transferred to a state school. That I do need to update the court on, because as it presently stands, he has been withdrawn from the state school. He travelled with his mother to Moscow because his mother wanted to be present for her own mother's chemotherapy treatment, and therefore he is presently in a Moscow school. And I can hand up to the court, because it explains the circumstances, the letter from OFSI, the Office of Financial Sanctions, which deals with that application and explains both the application and the reasoning for it. I'm not going to read it out for obvious reasons, but when it arrives with your lordships, I just want to draw your attention to the essential reasoning.
Thank you.
So paragraph 2 sets out the material that's provided, including a report and correspondence, and then over the page, at page 2, paragraph 7 describes the approach of OFSI to what it regards as...
We better just see what the applicant... Sorry, I didn't read the whole thing.
Certainly,
Just to ourselves.
I'm happy.
Just to ourselves.
Yes, sir.
Yeah, thank you. What was the particular paragraphs you wanted?
So I was going to draw particular attention to paragraph 7 and paragraph 13. So they, which in effect are an explicit acceptance that the child has mental health conditions requiring treatment, but the determination that those needs can be met in a state school with appropriate medical treatment, and paragraph 13, that it doesn't qualify as an extraordinary situation because, as they say, although the impact is significant, there is nothing in the case that is especially unusual or remarkable. Which will be a point that I will revert to when I address you briefly on the primary interests of children in circumstances such as this.
Yes, I don't. We may have it in one of the exhibits. I haven't turned every page here, but we got the obviously guidance, which is referred to in this letter.
We have not. We can get it for your lordship.
Well,
it's public document, so.
Yes, I mean it's not at the, as I understand it, at the centre of your submissions.
No.
But for general background information, I think I would be speaking to myself.
Yes.
I'd like to see it.
Yes. We can certainly do that. And it was in front of the judge below, so it probably should have been in our bundle. So, with that by way of introduction to the circumstance of this particular appellant, I was going to take the court for the purpose of developing the Padfield argument, just to look at the width of the statute and the circumstances in which somebody can be designated as an associate. The starting point is the Act which is behind flag 1 in volume 1 of your lordship's bundles. And as originally enacted, you have section 11 at page 7. The provisions of 11.2b were removed by amendment, so we can skip over those. But 11.3 remains the same, and that is that the provisions in any regulations must provide that an involved person is or has been involved in an activity specified in the regulation. And at D, an involved person may or must include a person associated with the person who is or has been involved. So a couple of points to note there. Firstly, the tense, that this can be unlimited in time depending on how you specify the activity. And the primary focus of this appears to be on the person my lord's described as the player, the person who's been involved in the specified activity.
Yes, in fact, as far as the statute is concerned, rather confusingly, an involved person
can be both.
Can be a person, can be an involved person,
Yes.
or an associate. Of an involved
Indeed,
person.
indeed. So you could have associates of associates. So, but I've not gone into the cumulative effect of that. But obviously, that is clearly a linguistic reading that's open to you on this. But anyway, I am going.
Ultimately, we're going to the regs to see what they've done.
We are going to go to the regs.
That's the enabling power.
Exactly, and as I say, just so your lordships have it, at page 9 is the statute as amended to remove the requirement in subsection 2 that there has to be any consideration given to whether the designation of the person is appropriate. That goes, and so you qualify simply because you are reasonably suspected to be involved. To a greater or lesser standard, depending on whether it's an urgent case or not.
Yes, I mean, I'm sure you had a reason for doing it. Surely, it's just more helpful for us to look at it as it stood at the time of the order, which is page 9.
Is at 9, yes.
You can then tell us as a matter of history that something else came out, but so effectively, 3, as you say, is exactly the same, and that's really all we're concerned with.
That's all you're concerned with. And then, just before I leave it, section 21, which explains why a United Kingdom person is going to be covered anywhere in the world, is because of the provision in relation to extraterritorial application at page 12. And then just skipping on, if we can, to the next tab 2, we then have the regulations. And again, just picking up the points, the extraterritorially, Regulation 3 covers conduct in or outside the United Kingdom by a United Kingdom person.
Sorry, I think you're getting a bit too fast. I see. I see, right. So,
United Kingdom person may contravene a prohibition wholly or partly outside the UK.
Okay.
And then the purposes, which is relevant for the Padfield analysis, are in Regulation 4 at page 18. And I think you can concentrate on A, encouraging Russia to cease actions destabilising Ukraine or undermining or threatening it. And then Regulation 6 defines the involved person, and you will see, firstly, that subsection 2, sub-reg 2, says an involved person means a person who's been involved in destabilising Ukraine or obtaining a benefit from or supporting the government of Russia. And again, it's probably Roman 2 you can concentrate on, because there is no suggestion that the appellant's husband has had any involvement in 1. It is the financial criteria benefiting from or supporting that is going to be relevant. And then D provides for associates is associated with a person who is or has been so involved. And that makes the tense quite important, because obviously destabilising Ukraine can fairly confidently be restricted to, let's say, 2012 onwards, Crimea being invaded in 2014, whereas obtaining a benefit from or supporting the government of Russia can be treated as being effectively unlimited. And in this case, there's no doubt that the appellant's husband's business activities in Russia go back, indeed before he met the appellant, to the early 90s, when both Alpha, the principal business in which he was involved, and TNK, the oil business, were founded and developed. The meaning of obtaining a benefit from and supporting the government of Russia is made explicitly wide by the definition that's provided in 6.4, which is over the page at page 23. And it's right in the middle of the page, my lord. You are involved in obtaining a benefit from or supporting the government of Russia if you carry on this is B, carry on business of economic significance to the government, or carry on business in a sector of strategic significance. I'm picking the two widest categories. Obviously, there are yet further ways in which you can do it, but effectively, if you are running a significant business in Russia, you're going to be caught.
Does the designation of the appellant's husband specify that he's been designated because of 4B and C, or are you merely saying that's what's likely to be the case?
We do have details of his designation in the statement of Mr. Reed, and I'm just trying to remember off the top of my head, but I believe it is B and C. I'm just looking at it. I'll ask.
Well, Mr. James Matthews.
But it will be that. I mean, the reality is it certainly mentions Alpha Bank, which was...
Yeah, okay. No, I assume so. I just wanted to know whether it's been...
So just carrying on with the review of the regs, you then get page 24, paragraph 6. Being associated with the person includes obtaining a financial benefit from that person or being an immediate family member of that person. And if you turn over the page...
Just 1 second.
Yes.
Yep.
And if you turn over to page 25, in the middle of the page, you get immediate family member. So you can see partner, parent, child, sibling, niece, aunt, uncle, grandparent, grandchild.
Yes, so that presumably must mean that you're a current wife or husband, are divorced with a parent.
I think that must be right.
Because for this purpose, the tense is it's the present tense,
present,
with
yes,
the present participle
yes,
being. Yeah.
But as I said, this is still a wide range of people. If, as I said when I introduced the topic, if one counts every family as having 2 children, this is 17 people, potentially, once you get grandparents down to grandchildren and the siblings. But obviously, having said that, the other way of being an associate, which is obtaining a financial benefit, is capable of being even wider.
Yes, there's a tense problem there too, isn't there? Because the governing tense in 2D is associated with.
Yes.
So it must be is obtaining a financial benefit, which is slightly odd, but you could say it wouldn't include has in the past received a financial benefit.
Well, in which case the appellant wouldn't qualify because...
No, quite. But I don't think, I mean,
Yes.
that's not an issue here because...
They've read it as is and has.
Were they?
The Secretary of State and those who've made...
So I had understood, perhaps wrongly, that they were relying only on B.
No, they've relied on A for pre-sanctions or prior to the appellant's husband being sanctioned on the 15th of March. He had made a number of very significant disposals.
Of course, yes, no, I understand that. But,
and they rely on that, yes. So she is...
Well, I don't, there's plenty for us to decide here without having to get involved there. I'm just wanting to understand it,
Yes.
though. It's not clear to me at the moment,
No.
but I don't think it matters that she qualifies under A
Yes.
as well as B.
Yes.
She qualifies under B, so that's all
Yes.
that matters. Yeah.
And then, so far as the effect on others, the reason you can't rely on charity, there are then a series of offences which I can probably just skip through, beginning with Regulation 12, page 29.
Hang on one second.
And just to pick up the point before we leave it, the appellant's husband is designated under 4C and D, Roman 2.
Sorry, I'm being slow. 12.
You asked,
Yes.
you asked me about...
I know you did, I just haven't got that. 12.
Sorry,
so page 29.
Yeah, page 29, making funds available to a designated person. Regulation 30, I'm just going to take the headings.
No, hang on, let me just read them.
Yep, sorry.
Okay, so as you say, 1 is the basic prohibition, and 3 is the offence. Yep.
Yep. And then indirectly making funds available is Regulation 13. So 1 is directly sending funds, this is making them available for the benefit. Regulation 14, making economic resources available, both directly and Regulation 15 for the benefit.
Is there a definition of economic resources?
There's a partial definition. In 4, which makes
No, it's already a definition.
that doesn't
so
really
that's-
help.
that doesn't help.
It's B is provides some guidance that they are capable of being exchanged for or used for funds, goods or services. Sorry, 14(1)B.
Well, again, this is all background stuff. But
yes.
so if the position is that it isn't defined, I'll just make a note it isn't defined.
And then there's a catch-all prohibition at Regulation 19. Which effectively prevents anything which has the effect of making available resources or funds.
I applaud the general instinct only to give us the relevant provisions. I'd be grateful if you could supply, at least in E form, the entire regs.
We can do that.
Quite often it's quite useful to have the table of contents to see how some of these structures interrelate. Yep.
Yep.
In fact, as a learning for the future, I think when one's going to do extracts, which I'm not against, we always at least have the front sheet.
Yes.
Okay.
So the position when one starts the Padfield analysis is, unlike many Padfield cases, this is a case where the purpose is made very clear. You've seen that in Regulation 4. It is the requirement in subparagraph A, in paragraph A, that the purpose of any designation must be to encourage Russia to cease actions in Ukraine. The difficulty that we submit presents itself to any decision maker determining whether the statutory purpose is served is where you have a category as wide as the associate category is. There is no reason to suppose, merely because you fall into that category, that the statutory purpose will be served. Now, I appreciate in saying that, I am taking issue with a central part of the judge's decision below, where she effectively determined that if you were in the category, prima facie, you could consider the Padfield question had been answered satisfactorily. And furthermore, she said, Padfield isn't concerned with any individualised consideration. That's paragraph 91 of her judgment. And again, we submit that's simply wrong. It's wrong if one just thinks about Padfield, where Mr. Padfield was a southeastern dairy farmer who wanted to complain about the price he was being paid for his milk. Spath Home, which is another case I'm going to look at, was a Manchester apartment block owner. So the judge's approach would say, Padfield's not engaged because if you're in the category, it's satisfied. In any event, I don't have to give any separate consideration to it. And in those circumstances, she considered that she could be satisfied that this designation was furthering the purpose.
Why isn't at the general level, which is what we have to start with, why isn't it enough for the Secretary of State to say that if I impose sanctions on associates of the player, the principal, that will, of its very nature, be a pressure on him or her to cease supporting the government of Russia in its Ukraine policy. In principle, any relative, even your grandparent or your stepchild or your nephew, whatever it is, who is being reduced to comparative poverty because of your association with your position as a principal, that will put a pressure on you to change your mind. Might be in any particular case a very small pressure, but we're talking here about the purpose, not about rational connection or anything like that.
So clearly, when you're dealing with associates, you are one removed from the player upon whom you can freely visit sanctions. And so inevitably, where you have an associate category, you are always, whatever pressure might flow from being designated, it is always at one remove, because the purpose of it, or the purpose of the regulation, prima facie, would be satisfied by moving against the involved person. And having their associates included may not make a difference. Now, I can accept that where you have a much more narrowly focused sanctions regime, if for example, you said people who are commanding the armed forces in Russian armed forces in Ukraine, or people who form the cabinet of the government of Russia, one can immediately see that because of the centrality of the player's role, that it is much more plausible to say simply sanctioning them may not serve the purpose of encouraging Russia to change its policy in Ukraine, and therefore it would be legitimate to have, at a level of generality, their associates sanctioned. But when one gets to the more remote players, that is, players who have nothing to do.
Remote non-players. Oh, so remote players.
Yeah,
right.
remote. So if we take
right.
the financial benefit players, people who've run a business in Russia in the 1990s and therefore are eligible because of the tenets, that you can then say, well, obviously, sanctioning their nephew will have an effect on them. But then the issue is, can it really be said that is capable of even remotely moving the dial in terms of encouraging certain behaviours by the Russian government? Now, it may be, the court says it is capable of it, but the reality is that where you have a range, much is made of the cumulative effect of sanctions, but where this category is concerned, associates, there are no more than a handful of people who have been designated as pure associates. Most people who are designated as associates, like Schwidler, are also designated because they are directly themselves involved persons in one of the categories. Mr. Schwidler was in the financial benefit category. But in the pure associate cases, which is where, in my submission, that the Padfield analysis should lie, it does not immediately, I would submit, lie in the mouth of the Secretary of State to say, oh, this will serve the purpose of encouraging the government of Russia to behave in a particular way.
I think my point wasn't so much about. Your points seem to me to go more perhaps to proportionality,
Well,
or
as I said in my opening apology, in a sense, these points may sound more powerful in the appellant's favour as in accordance with law or in relation to proportionality. But the fact is that promoting the Padfield test requires the policy to be promoted.
I was actually just reminding myself. I mean, Padfield, of course, we think we all know, but
Yeah, well,
in the case of
shall
some
I
of the
just-
court, we
I
can
was going to
cite
take
it
you
in
to-
our background. But
Yes.
what's the actual formulation in Padfield?
So I will take you to it. So I was going to take you to it actually in a later case, Spath Home, because it's got the passage.
Oh, that's
so
fine.
That's behind flag 5. Lord Bingham. So this is the Manchester apartment block owner complaining about rent control and saying that it's being used for an improper purpose. And Lord Bingham sets out the Padfield test at page 85.
Yes, well, that really supports my question whether this is really a Padfield point at all. Right? And you elegantly say, well, these points all run together, but you have split them out.
Yes,
and at the moment, the sorts of considerations you're quite understandably urging on us about both the remoteness of the player and the remoteness of the associate of the player need to me to go to proportionality rather than to what I've always understood to be the Padfield principle.
If the court thinks that having that extremely wide discretion to catch anyone can promote the policy, then clearly I'm going to fail on this point. But where you have a very wide discretion, and perhaps it's worth just picking up what Lord Hope said about discretion in the context of Padfield. If you don't mind just turning on to 108, I was just going to show your lordship effectively his summary of Padfield between D and F. Which effectively says that where you have a wide discretion, you are required to consider whether it's being used to promote the policy of the Act.
Yes. If, for example, you decided to use a discretionary power because you hated the person in question, but they were a political opponent of yours, or something of that sort. That's what Padfield is designed to obviate. That you're not using the discretion, however broadly defined, for the purpose for which the legislation conferred it upon you. But this isn't asking the question, is the means you've chosen likely to achieve that objective, or is it rationally connected to that objective? This is asking a pure question of fact. What was the purpose for which you used the power?
Yes, but if there is a disconnect between the discretion and the person who may be subject to it, and any prospect of it having a power to promote,
then, as my lord suggests, that may be analytically an argument to be made under the rubric of no rational connection between means chosen and objective, or it may go to a wider question of proportionality. But certainly speaking for myself, I don't see how it's got anything to do with Padfield.
Well, I'm not going to spend any longer on it, but the essential point that we would suggest does arise on Padfield is when you have a completely unlimited discretion, let's say to catch 50 or 100 people simply because they have a connection to a player, then you cannot say, oh, well, that serves the purpose of encouraging Russia because if I pick any one of them, it sends a message. Now, one can see, as I said to the judge below, that hanging someone arbitrarily from the yardarm like Admiral Byng sends a very clear message.
I've been thinking about Admiral Byng.
but
I think he was shot.
Thank you, my lord. I stand corrected. But one can see that you could, the Lords of the Admiralty could say, oh, well, that did promote the interest of the Royal Navy, but that's only if one regards the policy that allows you to do it as being a policy that simply allows arbitrary action to terrorise other admirals. And that's my point, that the policy of this Act is not to promote arbitrary designation of people who have no conceivable power to change the situation, and where their associated player has no conceivable power that hasn't already been motivated by their own designation, that is not promoting the policy. But I'm conscious that I've probably done as well as I can on that, but it is of the greatest relevance to proportionality and the questions about in accordance with the law, rational connection.
Before you leave the Padfield point, can you just help me with paragraph 84 of the judgment?
Yes.
Because the judge seemed to take the view that you couldn't even run it because of the change to the regulations.
Yes.
And what do you want to say about that?
So I don't accept that. So in terms of the change to the regulations and the removal of the statutory obligation to consider appropriateness,
yeah.
If you are asking the Padfield question, does this promote the policy, one might equally well ask, is it appropriate for policy reasons to designate? I don't accept that the Padfield question can't be characterised in that way. The judge says I was wrong to do it, but I don't know how else one puts into popular language the question, does this promote the policy of the Act, other than saying, is it an appropriate case in which to make a decision under the Act?
Can you just explain the change that was made? I think
Yes.
you very kindly, it's pages 7 and 9, I think.
It is. So just to go back to it, what goes from page 7 is effectively 2B. So there is no requirement, once it goes, for the minister to consider the designation of the person as appropriate, having regard to purpose and effects of the designation. And so the point I was making to the judge is, considering the designation is appropriate having regard to the purpose, it's a Padfield question.
Yeah. Thank you. Sorry to have interrupted.
No, that's quite all right. And so just so your lordships aren't misled by it, although Regulation 6...
Sorry, before we get... Was there any particular history to the removal of 2B? It was affected by...
It's affected by the Act behind tab 3, the Economic Crime Transparency and Enforcement Act.
Normally when something like that happens, it's, say, because of some previous litigation which has shown that this was that 2B presented an obstacle to the court, to the minister's exercise the powers in the way he wanted to exercise them, or something like that. I just wondered how it came about.
Well, it's clearly temporally connected with the start of the war in Ukraine, because it's comes into effect 17th of March. It may well be because of what was considered to be the convoluted thinking that was required in an individualised case, particularly in circumstances where it might be regarded as being unnecessary. If you were deciding to sanction President Putin, you didn't have to spend long on it. But in terms of associates, in my submission, its disappearance from the Act doesn't lessen the obligation. At least in that case.
Yes.
Because there are some
see, I mean, the principal obstacle which 2B would present in practice would be that the minister, even having regard to the parenthesis, might be under some sort of tame-side duty, I suppose, qualified by the parenthesis, to find out
likely effects.
Yes.
Although
to find out what the effect
yes.
on people would on individuals.
Although they remove the purpose question as well, and the purpose question, as I say, it is the reason why I said that purpose question hasn't been removed.
But the two go together, don't they, really? I mean, B1 is always going to be there.
Yeah.
You've always got to have regard to the purpose, that pure Padfield.
That's my Padfield point.
Yes, B1 wasn't to take that out.
No.
It was the meat of B2 was B2. Sorry, I'll start again. As originally enacted, what B was basically saying is you've got to do a balance, effectively, between the purpose of the regulation and the effects on the individual.
Yes.
So that's why B1 had.
Although,
And it was 2 that worried them.
Yes. Well,
They took 2 out, but then 1 went with it. Yeah. Okay.
Well,
that must be how it happened.
although it obviously doesn't replace the requirement for proportionality assessment, which is equally
No, quite.
present.
No, but I think, unless Mr. Blundell thinks it's important, but I suspect it isn't, but that's my understanding of why B2 was thought to present an obstacle and why they wanted it taken out.
But that's my answer to the judge's point. That disqualifies me from running Padfield. It can't possibly do that. Just as it can't disqualify me from running a proportionality argument, considering the impact of the measure on the person concerned.
So as part of your Padfield argument, you say the error of law is in paragraph 84 then?
Yes.
Yeah. Thank you.
The judge didn't actually say you couldn't run it. She said this does not shut off the possibility of an argument being correct, but it highlights the difficulty.
Well, it led to her criticising the way I formulated the question. I think she does it at paragraph 90. Criticising the way I formulated the question as being to consider whether or not it was appropriate to designate. And she says that is not an appropriate way of describing the Padfield issue.
Paragraph 90.
Sorry, 90, yes, you're right.
Well, I didn't read paragraph 90, and you may be right, but I didn't read it that way. She doesn't use the word appropriate there. But she's addressing a different argument there, as I understand it, which is really the point that I've put to you. What the judge, I think, is saying at paragraph 90 is that furthering the purpose is by no means the same as advancing or being likely to advance those purposes. In other words, you're confusing purpose with effect.
Yes.
This is what I keep coming back to, as my lord has said.
Yes.
That you have an aim in view,
Yes.
and you have the means chosen to achieve it. Now, if you want to criticise whether there is a rational connection or how effective, in fact, what you've chosen to do will be to achieve that purpose, that's not a Padfield argument. It may be a good argument, but it's not a Padfield argument.
I honestly have that, my lord. And I've given you my only answer, which is you can't divorce purpose from effect. You can't say, in circumstances where any rational response would be the effect is nil, but you're nonetheless in Padfield territory. Because you have a purpose, albeit one that's incapable of being achieved by what you're doing. Because whatever the purpose is, it must further encouragement of Russia. That is the specified purpose in Regulation 4. I'm going to come to Dalston in due course because Your Lordship, Lord Justice Singh dealt with a Padfield point that arose in Dalston, but I'm happy to take you there now just to deal with it. I'm going to say Dalston's got to be distinguished for a number of reasons, but would it be of assistance to the court just to look at the response to Padfield in that connection?
Entirely up to you.
Well, let's go to Dawson if the Lordships don't mind, so I can make a start on it. It's going to be in volume, it's behind flag 23 in volume 3.
Yes.
So the decision is going to be of significance to a number of aspects of the case. And I'll just identify where it deals with that. And so far as the first question addressed by the court in that case, it was the duty of the first instance court to exercise its own judgment rather than simply to assess the rationality of the original decision maker's judgment. And that is dealt with between page, well, effectively it's summarised at the bottom of page 978, paragraph 11, making the point that the question of incompatibility is a question of substance for the court, and then it reviews the cases that may have led courts into error in thinking that it was a rationality review of the primary decision maker. And the reason the court goes into that is because it concludes in due course that Mr Justice Garnham in the Schwidler case had indeed fallen into that error, and we submit Mrs Justice Cockerill fell into the same error of considering the rationality of the Secretary of State's decision rather than...
This is just a little trailer, this is not the point you're on at the moment.
Just a trailer, no. So the Padfield point is that then arises in relation to Dalston, which is the shipping point. And it arises in the following way. The regulations are dealt with at page 991, paragraph 46. And you can see there the power described to detain ships where they are owned or operated by persons connected with Russia. And the complaint was made that the purpose of those regulations was not to detain individual ships in UK waters, but rather to disrupt shipping, and this did not achieve that purpose. And that's picked up at 994 at paragraph 66. The Padfield test is set out, and paragraph 67, it is argued that this is effectively asset freezing rather than disrupting shipping. That's the argument. And paragraph 69, that it's doing nothing to disrupt the transport of goods because this was a pleasure yacht of some description, very large, but nevertheless a pleasure yacht, and therefore didn't serve the purpose. And Lord Justice Singh deals with the point at paragraph 71 on page 995 and makes the very straightforward point that even detaining one vessel is indeed disruption to Russian shipping. And the fact that there happened only to be one ship that could be subject to the restriction didn't make any difference.
Well, this is all very interesting, but what do we get out of this?
So what we get out of this is that you had a much narrower prohibition in relation to shipping, with a very distinct purpose, where you could say unequivocally a decision to detain a particular ship clearly is one part, I think as it's later described, as a chain of actions that might include 100 ships, and therefore, even if detaining one isn't likely to have any effect, it nevertheless will serve the purpose, because you're going to detain 100, and that will have an effect, and therefore it does serve the purpose. And in due course, we can see that's why the rational connection and proportionality test failed. And I just wanted to distinguish that, because as I think I've already emphasised, it is not the case, unlike ships, where the UK will detain any ships it can get its hand on. With associates, there is no question but that category, the pure associate, is used incredibly rarely. And therefore it is much harder to say...
Well, hang on. I don't quite see what to do with it, but do we know that the pure associates category?
We do.
There's evidence there.
Because we've got a list of...
It's in the evidence, is it? I've missed it.
It was in the evidence below. Those who are subject to designation are all listed, and the basis for their listing is described. So you can search the list for associate, and you can then work out, I think there...
Okay, but this is important to your submission. So I hadn't picked it up.
Yes.
And if you
I
say
think
it's
it'd
not
be
in the
common
bundle,
ground. I think it'd be common ground.
I dare say it is, but I'd like to see on what it's based.
It's based on the published lists of those designated by the UK.
Okay. So your point is that normally you only designate players. It's very rare to designate associates.
Exactly.
And you say that's common ground.
I believe it will be. I think it's something like 20. Somebody will give you. It's around that number. So there's something like
something like 20 what?
20 pure associates.
But I don't know that. I don't know how many that is until I know how many players.
15, just under 1,500 players. And again, we can get you the exact.
Well, if those are accepted as,
I think as a matter of broad generality, those numbers are.
I don't need to see the underlying material.
So I'm very grateful to Mr. Blundell. He's saying that is a broadly accurate picture of.
I think that's broadly accurate. I'll take instructions and confirm.
Thank you. Thank you very much, Mr. Blundell. That's helpful. Okay, so your point is it's very rare to designate associates as opposed to players. To designate what you call pure associates.
Yes.
That's people who are designated only as associates. Yes. Yeah. But where do we go from that that's relevant to Padfield?
So one can say where you have doubtful effects, which is effectively what Dalston was arguing. He's saying, well, why am I? This isn't Padfield because you're detaining a pleasure boat. That doesn't serve the purpose of disrupting shipping. And the answer that my lord gives is, well, A, you're shipping and you've been disrupted, but B, we're going to designate everyone who's in the UK waters. And it's just bad luck that there was only one of you, that the purpose is served by being able to do it across the board. Whereas here, there isn't the same purpose being served. It's clear that this is not being used as an across-the-board power so as to advance by using it across the board the purpose of the policy. I think all I'm saying is the Dalston answer doesn't provide an answer to this. The answer may be the one that my lord has proposed, that provided your motive by designating an associate is to advance the policy, albeit that it will have no effect, then that's the end of Padfield.
I prefer to use the word purpose because that is
yes, no,
that's hallowed in administrative law.
I accept that.
Yeah. But what I do suggest, and I have your answer, is that there is a conceptual distinction between purpose and effect.
And I also accept that. It's just whether there is a rational connection if there is no effect. So, can I then turn to the separate issues which are connected with the human rights? And there's no dispute that Article 8 and A1P1 are engaged, and therefore one is immediately into the familiar questions. And I'm going to deal with 3 of them. The first is whether or not association is in accordance with the law. And the second 2 are effectively part of the Bank-Mellat questions. Is there a rational connection given the width of the provision, and is it in any event disproportionate?
Just to be clear, if I may, that's an argument about both the legal regime and about the application of that regime to the facts of this particular case.
Yes, so
you're making both challenges.
I'm making both challenges. I have actually tried to separate them out, so when I address you on proportionality at this stage, I'm going to address you on the generics of the regime. When I come to address the court briefly on fair balance, that is an individualised consideration of the disproportionality in this particular case. But they both arise, Your Lordship's right.
Well, when you say fair balance, you made 3 headings. One, accordance
Yes.
with the law, which is a Article 8 point.
Yes.
And then 2 Bank-Mellat points,
Yeah.
rational connection and proportionality.
Yeah.
Fair balance, presumably, is another paraphrase of proportionality.
It is.
But why, in that case, why doesn't
Because
individual circumstances come into rational connection as well as it?
It does. It's because we separated them out in the grounds of appeal. So I was notionally thinking that's in ground 3, but it is equally well capable of being dealt with in ground 2. It's
Yes,
just
I
because
see.
you've got 2 separate.
So
steps.
effectively, the Bank-Mellat points have both a general regime aspect and
Yes.
an application to the individual aspect.
Yes. And indeed, in relation to all of these points, my focus is purely on the association legislation. This is not a challenge to the main act, nor indeed is it a challenge to the fact that the main act provides for association to be provided for in the regulations. It is that the way association has in fact been provided for in these regulations produces a law that is simply not capable of being foreseeable in its operation.
Right. So there is no challenge to whatever section it is of the statute empowering regulations affecting associates.
Yes.
Essentially, because associates aren't defined there.
Exactly, and so if you had sanctions against President Putin, you could completely understand that you would want to have sanctions against his wife or children. Though I think he doesn't have a wife now, but and we've seen that in relation to other regimes. Syria, a classic example. You have sanctions
No,
against.
I've got the point. Yes, thank you.
So the judge considered that the answer to the question of accessibility and foreseeability was the fact that it was relatively straightforward to determine whether or not you were an associate, because you could simply look at the definition, for example, of immediate family member and determine that you were therefore liable to be subject to sanctions. And in our submission, that is simply to miss the point.
So we're really now on accordance with the law, yes?
We are.
Yeah.
So the issue raised in relation to accordance with the law is not identifying who is in the category. It is relatively clear who is liable to be in the category, particularly if it's an immediate family member. It is identifying those people who are in the category who are actually going to be designated. It is a who question of the sort that has been considered by various courts. Who is going to be designated and in what circumstances?
Yes, there's no published guidance, is there? I think that, I'm sure there isn't, but I just want to be clear about this. There's no published guidance to decision makers about the criteria you apply or the considerations you look at in deciding whether to designate associates.
Correct.
One person's associates and not another's.
Correct. And so this is, in our submission, just squarely within the test, most usefully identified, probably trying to cut down on the amount of authority in the Supreme Court in their decision in Gallagher, which is in volume 2 behind flag 15. So it's a completely different topic, very closely controlled categories of previous convictions that are to be disclosed, but it deals with the question in accordance with the law, firstly by identifying it as a binary question, as Lord Sumption puts it, at paragraph 14, halfway through paragraph 14, 673.
Hang on. Whereabouts?
I was just picking that comment up at 7 lines down from
Yes,
673.
Yep.
Just by B.
No,
And then he turns to deal with accessibility and foreseeability in paragraph 17 over the page, 674.
yes, just pausing there. The measure has the quality of law,
Yes.
or it does not. It's a binary. You would say the measure is not the regulation, but the application of the regulation to an individual. Is that right?
No, I would say it's the regulation.
Sorry, yes, I was confusing myself.
Yeah. And it's the specific associate regulation, because as Gallagher and indeed a number of the other cases show, the Supreme Court go on to say it's this section, it's 86.4 here, that's not accessible, rather than looking at the Act as a whole, which is why
Yeah. Okay, perhaps I should give us the rest of the passages you wanted to
So
refer us to.
paragraph 17, my lord, which I would invite you to read in full.
Yeah.
And you may not be surprised to know it's between C and D that we place particular emphasis.
Do you mean C and D?
Sorry, G and H. Just failed the sight test. A power whose exercise is dependent on the judgment of an official as to when, in what circumstances, and against whom to apply it, must be constrained by some legal rule governing the principles on which that decision is to be made.
Does it follow that you can never have discretion, or at least you can only have it if you support it by some guidance as to how the discretion will be exercised?
So it depends on the context. Obviously, there can be some discretions which are naturally constrained by the statutory scheme if you have a very limited set of categories where discretion can be exercised. In fact, Gallagher's probably an example of that, where there was no real discretion as to which convictions fell into which pot for the purpose of disclosure, except for one set, which were the multiple convictions, which is why I said in the end the court looks not at the statute as a whole, but at the particular provisions for the purpose of conducting their analysis. But whereas here you have an immensely wide category of people who might be classified as associated for the purpose of designation, then there has to be either it has to be implicit in the statute, or there has to be guidance. And the role of guidance is accepted as being sufficient to satisfy the in accordance with the law principles, as one can see from 682, Lord Sumption cites the decision in Cat, paragraph 31.
One second.
So that's the Lord Sumption's analysis of the Strasbourg case law at that stage. E.
It doesn't deal specifically with the role of guidance.
No, but one can see that comes from
Certainly well established.
yes,
It
there is a passage dealing with guidance. I'm just trying to find my reference to it.
It goes back to Silver.
Yes.
And I think we try to summarise all of this in Bridges.
Yes. And it certainly comes out of the decision in Purdy, which is on 683, which is, I think, recognises guidance both from the court as well as in the terms of the statute itself. 687, thank you very much. Paragraph 43. And we can see there that part of the reason that it was determined that the Act gave sufficient foreseeable guidance was because there had in fact been guidance published by the Secretary of State, well established that guidance may constitute law for the purpose of the Convention. Citing Purdy.
My recollection, and I don't want to take you out of turn at all, is that in Bridges, one of the reasons we found a defect was because
exactly.
the policy didn't cover.
I was going to go to Bridges next. It's actually the next flag, flag 16. So this is a automated facial recognition trial programme which came before Court of Appeal, and the court were invited to consider what was described as a relativist approach at the bottom of 749, reading over to 750. In other words, the more intrusive the Act complained of, the more precise and specific the law must be. And I'm also bound to say I make the same concession as Mr. Squires in that case, that that is an appropriate approach to in accordance with the law. But as my Lord Justice Singh says, the reason that the scheme operating the facial recognition programme was held not to be in accordance with the law was because it failed to answer at paragraph 91 the who question and the where question. Which was effectively because it gave no guidance as to who was going to be on the watch list, which the programme was going to use as its starting point for analysing faces, or where the cameras are going to be set up for the purpose of capturing people on the watch list. And in my submission, that is the answer to the judge's approach to the question of accordance with the law, that it's enough if you know that you are within the category of associates without having to know who in that category might be chosen. And in our submission, that's simply not enough. That may be an answer to accessibility. Arguably not even that, because you can't regulate, particularly in relation to the associate categorisation, there's no way of regulating your conduct so as to try and affect whether or not you are either A, going to be an associate, or B, going to be designated as such. Because as I say, of the historical reality that...
Is that a point in your favour or against you?
It's a point in my favour, my lord. That
I may be misunderstanding it then. One of the arguments that something doesn't have the quality of law is that a person will not know how they can regulate their conduct.
Yes.
But your point is, well, the point you just made seems to tend to show that doesn't really matter in an associate's case, because you either are an associate or you aren't. There's nothing you can do to regulate your conduct.
You're right. Of course, your lordship's right to the extent that if you're a child, there's obviously nothing you can do about that. But the point about foreseeability and accessibility is at least for somebody to say, but because the guidelines say that if I don't take money from my father, or if I repudiate him publicly, or that there is some other aspect to my conduct other than simply being a child, that I can then deploy in order to, I may not be able to get out of the category, but I may be able to get to a point where I can say, now I can avoid being designated because they've told me that you're only going to get designated.
Yes, I see.
Yes.
It didn't immediately occur to me that there was anything you could do that might have that effect, but you say we don't know what the criteria are. They might be things just like that.
Yes, exactly.
Yes, okay. Thank you.
But what we do know, I think, is that they don't just designate everyone who falls within the statutory definition. As I understand it, they give an individualised consideration to the facts of each case, and they conduct a balancing exercise.
Yes.
And you would say that, in fact, they're required to.
Yes.
That's what the Human Rights Act requires them to do. Now, one of the rationales for this concept of law, the quality of law point, as Lord Sumption said in Gallagher, is to guard against the risk of arbitrary executive conduct.
Yes.
Now, you're not going to get that here, are you? Precisely because they can't just designate everyone. They have to choose who, within the statutory definition, will in fact be designated, and they do it, I think it's suggested, in accordance with the principle of proportionality. So where's the risk of arbitrariness?
But because you've got rid of the first question that I've called the Padfield question.
Yes.
Is it appropriate, given the purpose? Unless you ask and answer that, whether it's under Padfield or whether it's under this rubric or rational connection, then you're not going to get a sound answer.
But doesn't that come in?
Because you assume it. But that's the problem, that their proportionality assessment assumes it serves the statutory purpose.
Well, hold on. Isn't one of the ballot questions whether there's a rational connection?
Yes.
So why wouldn't you be able to make these kinds of arguments under that rubric?
Because in terms of all the apparent analysis that goes on the part of the Secretary of State, all one is seeing is there is a connection between the associate and the involved person, and therefore it serves the purpose because the associate will put pressure on the involved person. In fact, that actually wasn't the reasoning in our case. The original reasoning was because it was said that the appellant would put pressure on the government of Russia, which was improbable. But the ex post facto rationale given by Mr. Reid in his witness statement was actually it's because she'll put pressure on her husband. But if one treats that as being without more a legitimate policy choice, then all you do is say, well, that's a legitimate policy choice in relation to this monolithic construct of sanctions where you can't separate out any one part of the regime, and therefore the proportionality argument, considering the harm that is caused to the person designated, is always going to be lost, that there is never any proper individualised consideration. Now, if my Lord is saying that proportionality analysis should be individualised consideration of not just purpose but effect of this particular designation, because we're not going to designate everyone, and then individualised consideration of the impact on the person concerned, then that might lead to a decision that doesn't violate. But that's not what happened here. It's not what happened here either.
Yes, forgive me for interrupting. As subject to what we may hear from Mr. Blunt, I would have thought that the bank ballot questions do have to be asked and answered in each individual case. Now, I thought that's what they were doing. They may not be getting the answer right, and that's your round 3, I think, but I thought that questions like whether there's a rational connection between the means chosen and the aim in view are part of what has to be gone through.
Not one that looks anything like the Bank Mellat question, because obviously the Bank Mellat question is, why pick this one Iranian bank when you've got 26? And that, I would say, should be immediately transplanted to this. Why pick the wife of Dingemans Khan when you haven't picked wives of umpteen other, much more closely involved players in the Ukraine conflict?
We don't know, do we, how many players have wives resident in the UK?
We don't, but the fact residence or non-residence doesn't appear to be a motivating feature.
Well, I don't know whether it does or it doesn't. A very untutored view, but you may tell me so I don't understand how it works, is there's not much point in sanctioning Russia-based wives and children because they don't have any assets here to freeze, might possibly put travel bans on them. But the ones who are living here and have huge assets here, there is an obvious, assuming the other points, there is an obvious point in doing it because they will feel the pressure. You won't feel the pressure if you're sanctioned and all you have is a huge apartment in Moscow.
Well, I would approach it slightly more widely. So the players get sanctioned whether they're UK residents, UK citizens, or Russian. There is no apparent policy to only sanction people who might feel forced because they're present here. Indeed, for the reason I've already explained, that if you are designated, you immediately become a person excluded from the United Kingdom. And so, again, I can't give you the numbers, but I would guess of the 1,200 men, probably 1,100 of them are not UK citizens. And of the wives.
I take the point about players then. Well, part of the problem is there's no evidence about this, and of course that's a point you can turn to your advantage.
Yes.
We don't know we frankly don't know why she has been chosen. We can assume, not all, but the great majority of the players will have family of some kind, probably wives or partners.
Yes. And they certainly will have people who've...
It's only my speculation that they've focused on the ones who are known to have big assets in this country.
Yes.
But
But again, that would at least provide guidance of a sort that would allow you to conform your behaviour to it. No.
Well,
I'm going to give away the money.
Not much you can do about it.
Well, you can say I'd like to contribute this all to Homes for Ukraine. If that frees me from this obligation because it's just the money, have it.
The reason why you have to have the quality of law is in part about what you've just described, which is the ability of an individual to regulate their affairs with some reasonable certainty. But I'm not sure that exhausts the entirety of the rationale. And certainly looking at Catt and Gallagher, one of the rationales, I think, is to guard against the risk of arbitrary executive
capricious,
behaviour.
exactly.
In other words, that if, for example, you're going to launch judicial review proceedings, you have to have some foundation for it. You can't just speculate. And if you have some published criteria and they haven't been followed, well, then you may have the foundation of an argument that there's been some abuse of the law in this particular case. I'm not saying I accept your argument, but I'm just suggesting that there can be values which are served by the quality of law point, which go beyond whether you can do something about your affairs.
Exactly, and a way of testing whether what has happened is merely capricious or whether it has some proper foundation by connecting both to policy, effect and decision. So the reason that I think it's just one part of the law under consideration in Gallagher was held to fail on human rights ground was because if you had a rule that operated completely capriciously, then it couldn't be regarded as being necessary and proportionate. So the rule of law question or the in accordance with law question is there to help you answer that, because if you can't answer the in accordance with the law question, then you can't answer the proportionality question.
Could I just ask one other question? Although you have disowned any challenge to the lawfulness of the regs as regards players, wouldn't the argument you're advancing now on the quality of law apply equally to them? There are, goodness knows how many thousands, tens of thousands of people probably, who fall into the very wide definition of involved persons. If your argument is right, wouldn't you say it's entirely a matter of executive discretion which ones you choose, and that's not good enough?
So I think, were I representing a player who qualified under the financial benefit head, that might be a viable argument. It wouldn't be a viable argument for being part of the action against Ukraine, because that does give you enough content so far as designation is concerned to understand that if you are a person who effectively has been responsible for promoting actions that undermine Ukraine, even if you're not entirely certain as to how many people in that category are going to be chosen, that does give you quite precise information about the conduct you should either cease or refrain from committing in order to determine whether or not you're going to be caught by this regime. In a way, Bank Mellup comes to help us, that in the end, if you've got an extremely wide category in which one or two may be chosen, that does suggest that the law is lacking in the quality that then allows you to assess proportionality. But if you're dealing with a category which is a relatively small category, the people who are supporting actions against Ukraine, then that's less of a problem.
Can you just help me? In Bank Mellup, was the legislation itself found to be not in accordance with the law? Or was it that it failed under the proportionality head?
It failed under the proportionality head. So it wasn't, that's not right. So it failed on both, but it failed on in accordance with the law because it was impossible to assess its proportionality, because there was never any explanation as to why an ostensibly wide power to designate Iranian banks had only been used. And so, as it were, it was not in accordance with the law because of that reverse engineering, but it just establishes the link that I was discussing with your lordship, that if in accordance with the law is there to let you perform a proportionality analysis.
Well, it's rather like Joe was saying about Padfield. It's the sort of case one thinks one knows backwards because one only knows the passages that are regularly cited. I'd certainly forgotten that was the analysis. I've been reading it over lunch. There's not anything in the bundle of authorities, is it? It's out on the basis that we all recite it in our sleep.
It's not.
Well, anyway, I've put the parties on notice. Yes. I shall be reading it over lunch.
Yes, but I mean the point about Bank Mellup, and I think this is an accurate representation, at least what Lord Sanctions said, was it's not the measure itself sitting alone, but the measure as applied that has to be subjected to both stages of the analysis.
I'm not sure that's right. In Gallagher, he says very clearly
Yeah, it's
that
binary.
in accordance with
Yeah.
law is a binary question.
Yes.
And he actually makes the point that even though it serves very important public purposes and may well be proportionate, if it fails because it's not in
Yes.
accordance with law, it fails.
Yes,
It doesn't matter how much you
Yes.
need it,
yes,
you can't have it.
yes.
That's quite a big thing to say. Whereas if you can get past the in accordance with law threshold, then you can engage in a proportionality assessment, which, as he says, is a question of degree.
Yes. I don't shrink from the binary proposition. That's why I took the court to it. But considering questions of foreseeability are softer issues which do involve a requirement to look beyond the language of the Act and to consider the way in which it operates in practice. So to that extent, the purity of the analysis is blurred because of the quality of foreseeability.
Right, where do we go now? We're still in accordance with law.
We are.
Really
So
sort of
I
answered
was
some-
going to go to rational connection, which perhaps can be done a little more quickly. So, in a way, the answer to this is Bank Mellad. That once you recognise that there are a handful of associates designated as pure associates, and in the absence of blanket economic sanctions against all associates, it is very hard to conclude, even if the purpose is served, that it's going to have any effect. Because unlike Dalston, you're not looking at a blanket rule that's going to be applied to all Russian shipping. You're looking at a rule which has to be considered as it has effect in relation to only one person, or a handful of people. So although I accept you don't have to have a perfect fit so that you can say, I can see exactly how this law is connected to the purpose, and I can see exactly how this particular designation gives effect to that purpose, you can't see that at all here because of the why and who. Why has she been chosen? We just don't know.
Well, hang on. At the moment, I don't see a rational connection between not knowing the why and why this particular person was selected and there being no rational connection with the object of the legislation. Suppose you had 20 wives, all of whom you actually knew were very influential with their husbands, and you'd only chosen 5 of them arbitrarily. You might have a point at the time we were previously looking at. You might have some version of proportionalities. I don't know whether we have some sort of selective prosecution rule in this country, but I suspect it can be got in somewhere. But the one thing you wouldn't have was saying that it wouldn't have anything to do with rational connection. The rational connection would be these 5 who we've chosen will be able to influence the players. And that's a rational connection, isn't it? And the fact they've been chosen arbitrarily and they could have chosen another 15 may be another ground of unfairness, but it is not anything to do with rational connection. Am I missing the point?
Your Lordship's addressing rational connection as if it's Hadfield in a different form, and of course it isn't. It's rational connection to the legitimate aim of the legislation. So
It's asking that will the step which I am challenging, the decision that I am challenging, does that have a rational connection with the purpose of the legislation?
No, with the legitimate aim of the legislation.
Oh,
which
all
is
right,
going
sorry, well, I've expressed myself back, but it's still the same point, isn't it?
Well, no, because it means I'm not hoist on the purpose against effect problem that my Lord Justice Singh was putting to me. I am in this context able to say, if it's going to have no effect, then it doesn't.
Yes, but I'm putting to you a point that it...
Yes.
I'm saying, your point is... I thought you were confusing 2 points. Your point, an unfair selectivity point.
Yes.
With a point which may well be the case, that this one individual, and certainly this individual, given what we know about her and her relationship with the player, will have no effect, and therefore there's no rational connection.
Yes.
So what's selectivity got to do with it?
So selectivity has so again it's this approach. So in considering rational connection, you can look at it at a high level of generic abstraction. You can say, what's the effect of designating wives? Does that have a connection? Does that serve a legitimate aim? Answer no. And then at a specific level, what's the effect of designating this wife? Has that got a rational connection? Answer no. So I don't mind which way the court approaches it, but both the legitimate ways of analysing.
Yeah, I see the point. Maybe I've simply misunderstood what you were saying. I get the basic point, of course. Yes, I just didn't think it had anything to do with having chosen 20 when you could have chosen 50. Or 1 when you could have chosen 100. You know what I...
Yes.
Yeah. Okay.
Well,
let's not spend any more time.
I mean, there is a point. It's the Bank-Mallat point that in the end, if you're choosing 1 when out of 50 who are covered by the legislation, then you have to say, how is this rationally connected to stopping Iranian banks if all you've done is stop Bank-Mallat? If you're saying the purpose of having associates is to make players worry about their wives, how does it help if you just choose 1 wife?
This is really the foundation of the House of Lords decision in Belmarsh.
Yes.
We heard a lot of argument about Belmarsh in the Schwidler case from counsel.
Yes.
Mr. Schwidler, who placed great reliance on, and the analysis in the Belmarsh which he presented to us was that in Belmarsh the legislation had the purpose of combating international terrorism.
But only foreigners.
But only foreign nationals were to be detained. And therefore, what the House of Lords ultimately concluded was not only was that discriminatory and a breach of Article 14, they also concluded that for the same reason, the means chosen had no rational connection to the aim in view.
Yes.
So is that the kind
That
of
is
analysis
exactly that is exactly.
Something else, Mr. Williams.
Well, my lord, I'm sorry that our citation of authority has proved to be quite as deficient as
No,
it has.
we normally rather approve very economical.
We did have some very, very great strictures on the number of pages placed on us. So we have
What, placed on you by
the Court of Appeal, the admin, my lord. But
yeah, you're always allowed to apply for more, but don't worry, I'm not teasing you. We will.
it's
We
very
can
well
look at any
my
more we
junior
need to.
who's had to struggle on page count for some time.
Yep.
But yes, that's exactly the point. I don't think I can add anything to that. So that then brings me to the question of proportionality, at least at the level of dealing with it generically. So I am going to deal with this now, my lord, only by looking at it at the generality of the application without looking at the particular decision, because the particular decision I've separated out and I'm going to deal with it, as it were, then. And can I say straight away that I certainly accept the principle that was confirmed both in Christian Institute and Safe Zones, that if one is looking at the statute without regard to how it's actually applied, so an ab ante challenge, that is a challenge before it's actually used, then I have to prove that it's not capable of being applied compatibly in all or almost all cases. And again, I emphasise this is focused on pure associates. So associates who would not otherwise qualify under any guise as players. In my submission, it is always going to be disproportionate to include pure associates because they will invariably be people who have no culpable involvement and no active involvement in any of the prohibited activities which form the bedrock of the regulation. Your Lordships will remember that when we looked at the regulations, it was clear that one of the statutory requirements for any lawful regulation was that it had to identify the activity, the prohibited activity, in a way that was capable of serving the purpose. If you do that, and if you say it's that activity that we have to target in order to have an effective sanctions regime, then the associate category, the pure associate category, who have nothing to do with that activity, in my submission are always going to, or almost always, going to lead to incompatible and disproportionate.
The prohibited activity being what? Encouraging Russian conduct.
So the prohibited activity in our case is destabilising Ukraine.
Yes.
Or obtaining a benefit from the government of Russia. So the associates are always going to be people who haven't done any of that.
No, but they might have influence on those who have.
Well, my lord, I recognise that an effective use of that influence on those who have might, in a small handful of cases, be regarded as being proportionate. So if you want to sanction President Putin's girlfriend, fine. You can see immediately that it might be a proportionate reaction. But where you're sanctioning thousands of people who have more or less involvement right at the bottom of the food chain, then I would respectfully submit that in almost all those cases it will be disproportionate, because you are weighing the influence, and I do make the point that I made earlier, the second-hand influence, because one's assuming that the player's already been sanctioned. So there's already powerful pressure on the player because he himself is liable to come under the regime. But that somehow the inclusion of the wife, the girlfriend, the child would have an effect that is capable in an appropriate number of cases of outweighing the harm to that person. That, in my submission, that's going to be a very rare case. There will be cases.
Well, is it, I mean, we have to spell out exactly how this is supposed to work. It's not, as I understand Mr. Reed's evidence, simply that the wife will pick up the phone to the player and say, look, things are terrible for us here, and or any arguments they may want to develop.
Yes.
May say, actually, what's happening in Ukraine is terrible. May say nothing about that. May just say, what's happening to us is terrible. And please, please, please tell President Putin to
Yes.
change course. that's, as it were, personal influence. Another thing which may come down to the same thing, but I think is nevertheless probably more likely to be how it happens, is, if it happens at all, is that the player will simply see what is happening to his wife and family, and irrespective of any particular pleas, whether he picks up the phone or not, will say, this is terrible, I can't have my children suffering like this. And that's really the object. The object, you know, whether it happens to be mediated through the wife's pleas or not, the object is, this is, I don't want to be plain speaking about this, is to punish the families so that the players will be influenced to change course. I don't know quite how that feeds into the analysis, but talking about the degree of influence that the wife will have over the husband isn't really attacking how this is supposed to work. I think Mr. Reed goes that far. I mean, obviously he's a bit coy about putting it, well, it's a form of, you know, collective punishment, but
it's a slightly murky picture. So the original decisions were both based upon the appellant having influence over the government of Russia.
Yeah, but that's gone. That was truly, that's a good debating point for you, but it's not the justification that's now.
No, he certainly hints at, although I don't believe he goes as far.
Well, it's slightly. There's a long paragraph.
There is.
Which is a bit of a moving target. I don't know whether you have any submissions about that. In which case you can come to them when you were going to, rather than now.
Well, I mean.
But I was just picking you up on the talk about whether whether the wife can influence the husband. It's not quite that. It's whether what is happening to the wife and children will influence the husband.
Okay. And so, even if one accepts that as a potential human reaction that the policymakers may be contemplating, that if I'm cruel enough to the family, the player will do something about it. Even assuming that was a legitimate policy approach to it, and as I understand it,
well, Mr. Blundell's may say that's not supposed to work at all, but that's what
But the point I would make to that is that the idea that it's that secondary effect that may have such great weight that it justifies you visiting the force of the sanctions regime against the associate is the issue that I raise. If one assumes that you have somebody who has already been, they're a player, so they've already been subject to sanctions, so they already have powerful personal reasons, if they were willing to do it, to say to President Putin, look, you're ruining my life, please get out of Ukraine. The idea that the additional imposition on the will of that person by involving their family is of sufficient weight to outweigh the harm to the family, the blameless family, is in my submission where I would say the proportionality balance fails at that generic level. That you simply cannot achieve enough by using draconian measures against family members to justify the harm that it causes.
Does it follow from that submission that even if, in a hypothetical case, in the individual case it would have that effect,
yes,
and it would be proportional,
yes,
that person also benefits from
yes,
your analysis because the legislation is unlawful?
Yes. So the ab ante challenge says if it's incompatible in almost all, so I'm allowing for your lordship's outlier. Yes,
I understand that. So what you're inviting us to say is that we should say the legislation as such is unlawful,
yes,
and therefore you're not entitled to go on to conduct an individual
just looking to check there's nothing else I need to. Yes, I mean, probably it is just worth, if you've still got Gallagher open, I suspect it's either Bridget or Gallagher you've got open. It was just to draw attention to the conclusion of Lord Sumption in Gallagher, which I haven't shown you, at paragraph 63, page 695. Which is the one section that failed the ad ante challenge, and perhaps just to look at his reasoning for saying it failed. And it's to do with the enhanced disclosure rule that was triggered by what was regarded as being a multiple conviction. I don't think your lordships need to know the particular terms of the rule, but as Lord Sumption sets out, it had a rationale, because obviously serial offending is considered to be more serious and may indicate propensity, but that the way the rule was framed applied irrespective of the nature of the offences, or of their similarity, or the number of occasions, and therefore incapable of indicating a propensity. And maybe I'll make my comment later. And so.
Sorry, where are you reading from?
My lord, I'm 695.
Yes,
in
but whereabouts?
paragraph 63 by F.
Down by F, right? Thank you.
And the fact that the rule didn't provide sufficient criteria so as to serve the purpose, but namely to identify the propensity cases. And he refers to this having the rule being coincidentally establishing propensity in some cases, but not in a great many others, having, as he put it, eccentric consequences. And he cites the case of Gallagher. And at the bottom of the page, he says, a rule whose impact on individuals is as capricious as this cannot be regarded as a necessary or proportionate way of disclosing criminal records indicating a propensity. And I would respectfully suggest that the answer to the generic consideration of proportionality is that this is an equally capricious rule. It does not have the contents that would allow you to identify the people who really might have influence with the players.
Or, as I would put it, harming whom may not influence the players.
Yes. Yeah. Or won't influence the players sufficiently. In other words, that you haven't got to the nub of the thing you want to achieve, which is real influence on somebody who matters. So that brings me to the individualised consideration of the proportionality of the decision in this case. And the first point that we make is that, as in Schvidler, and in part because she was following the decision of Mrs Justice Garnham. Sorry, Mum.
Just before you
Yes.
embark on that stage of your submissions, do you or do you not accept that in relation to the individualised consideration of proportionality, that this is a Category 3 case, as I analysed the 3 categories? In other words, that the role of this court on appeal is not simply to do the individual proportionality exercise again, but to ask ourselves whether the judge was, quote, wrong, unquote.
Well, my lord, I do. I think your lordships know that the case Dawson and Schindler's in the Supreme Court in January or February.
Oh,
So,
we didn't know the time, we knew it was Jane.
I've been given Lord Anderson gave me the date, so somebody will remind me and I will be able to give you the date for it.
And that is the that is one of the issues there.
That I would have to check, but I suspect it is. But actually,
Oh, of course, yes, sorry.
Not for Schindler, actually, possibly for Dalston, because obviously Schindler court held that Mr. Justice Garnham hadn't performed his own judicial assessment.
Is Dalston going on appeal? I'd heard that Schindler had been given
Mr. Blundell is most likely to know, or those behind him are.
We'll take instructions.
Sorry?
I'm taking instructions now, Mum.
Could you? Yeah.
But yes, my lord, I do. So we put it in 2 ways. Firstly, we say there's the same error here that was apparent in Schindler. But secondly, if it isn't, then I have to show it's wrong in the Extradition Act sense.
If it assists, I've just been told both cases are going on appeal, 15th and 16th of January.
Thank you.
So my primary submission is that the judge failed to form her own assessment, and therefore we would not invite you to remit. As in Schindler, we'd invite you to form your own judgment about where the balance should be assessed as lying. The second point we would make is, in any event, the judge's assessment was wrong for 3 distinct reasons. Firstly, that her analysis of the weight to be given to the importance of the sanctions regime involved too much deference or respect, whichever term you want to use, and failed to analyse its individual weight in this individual case. Secondly,
Hang on a second. The analysis of the weight to be given to what? Sorry, to the
individual importance of sanctions in this case, rather than viewing it as a monolithic whole which can't be broken down and therefore has to be regarded as being, as she put it, of almost insurmountable weight.
Okay.
So that's the first point. Secondly, that she, like the Secretary of State, failed to recognise the importance of the children and family aspects of the case as being a primary consideration. Both the Secretary of State and the judge refer to the family, but they show no sign of having done what the cases suggest they should have done, which is to say, we will consider first the interests of the children, particularly. Well, he's now 12, but the youngest child. And that simply didn't happen. And then thirdly, we would say it's wrong simply because, on any view, the decision was obviously disproportionate. Obviously disproportionate.
Well, having trailed that, I know we're a minute or two before
Yes.
1 o'clock. How are you doing time?
I'm doing well. I will finish. I will finish this topic in half an hour. I'm going to take maybe 20 minutes on the point that there's no leave on, because in a way it's very much contingent on how your lordship say that this part of the argument should be approached, because if there isn't deference, then judicial review principles are going to allow sufficient remedy. If there is deference, it's only then that we say the Section 38 judicial review remedy isn't giving us sufficient access.
Thank you. Well, that sounds as though we're not going to be in any time difficulties, but we will see.
Yes.
Good. Give me one moment.
I'm assuming your lordships will be helped to have copies of Banknolet and Belmarsh as well as the other.
Yes, I think so. Thank you.
So we can load them up to the CE file if that's convenient, unless you'd rather have them directly
I
to the
think,
clerks.
frankly, direct to the clerks. I mean, I should probably not wait for them to arrive,
No.
but yes, direct to the clerks is more efficient. Thank you.
What was it, Adrian?